Recording has started.
Okay. Good afternoon, everyone. I hope we're told that you can and should be able to hear everything that we're about to impart to you. I'm, as you can see on the screen, SarahBlackmore. I also have with me Jacqueline Thomas, King's Counsel. We are both joint heads of chambers at Spire Barristers, and we have a lengthy background between us in public law children cases. And back in 2013-2014, we were the authors of a book called Family Justice Reformed, which was designed and published at the time of the inception of the Family Court and the beginnings of the Children and Families Act 2014. Since that time, we've kept a relatively close eye on developments in the Family Court, and it's this afternoon that we are intending to run through the processes that we have now involved in particular since January of this year and the relaunch of the public law outline. There is obviously a PowerPoint presentation linked to this talk this afternoon, and it will be made available to you all by email, I think tomorrow, following the conclusion of this presentation. So just to give you a little bit of an overview of what we're going to cover this afternoon, we are going to just briefly go back to 2014 and remind ourselves of what the Children and Families Act 2014 and Practice Direction 12A brought to public law proceedings. We then, of course, were hit by the pandemic, and that had a huge impact on the processes of the Family Court and in particular care proceedings. But we'll have a look at that and what the implications of the pandemic were and the guidance that all family practitioners were given by the President at that time. We're then going to move on and have a look at, in particular, the relaunch of the public law outline and the public law working group's report of March 2021, which highlighted and gave various pieces of recommendations to all family practitioners or care practitioners in particular to implement. We'll then look at, given that this talk is about reverting to 26 weeks, and look at various scenarios and situations where it might be necessary to seek to extend that 26-week statutory time limit. We'll then have a look at some very recent guidance and recommendations that have come out of some further work undertaken by the public law working group in relation to supervision orders and the most up-to-date position as far as those are concerned. And then finally, this afternoon, we'll have a look briefly at the updated standard order templates that have been released by Mr. Justice Peel last week, and what the obligations on us all are likely to be after that. So if we start then with just a brief look back to the coming into force of the Children and Families Act on the 22nd of April 2014. I'm sure that you are all fully aware that that act was the one in which, alongside extending the implementing the 26-week time limit for Part 4 Children Act proceedings by virtue of Section 14, it also created the single family court that we are now all used to practicing within. I've already given it a little bit of a plug, but the book that Jackie and I authored back in 2014, which was updated in 2016, Family Justice Reform, sets out in detail the processes and the practices that we ought to have been implementing since that time. And I think it's fair to say that we were very good prior to the pandemic of making sure that we were compliant with PD 12A and getting through cases. And Jackie in a moment will have a look at where we've got to back in 2014, 2015. Just briefly then, in respect of Practice Direction 12A, as you'll see from the presentation slides, we have put into the document that you will get in due course links to, hyperlinks to all of the documents and statutory provisions that we are referring to. But just briefly, and as a reminder about the public law outline and what that implemented and what we are now being asked by virtue of the relaunch of this PLO to get back to, is the relatively, I would say, straightforward process of the PLO, which is in 4 key stages. I think we've lost the slides. No, it's appearing on that. Sorry, forgive me. My screen seems to have gone blank as far as the slides are still showing. Thank you. So as you can see on this slide, there are 4 key stages to the public law outline. The first, and it's important to remember, is the pre-proceedings work that local authorities should be actively engaging with before those proceedings are issued. I accept, and I think we all will accept, and it's a theme that runs through this presentation and just generally, that there is an acknowledgement that everybody within the family justice system is working at the outskirts of capacity, that there are pressures, that there is a shortage of staff, of money, of time, but the best place to be in ultimately is before the proceedings are issued, to ensure that the assessments, etc., are undertaken and concluded well in advance of actually issuing the proceedings, so that it's then in a relatively straightforward case, a process by which the 3 stages of the PLO are relatively smoothly dealt with, so that there is issue and allocation hearing. The court gives out a case management hearing not before day 12 and not after day 18 of issue, which should give everybody involved the right amount of time to have advocates meetings and to prepare ready to have an effective case management hearing. And thereafter, there should just be one other hearing, the issues resolution hearing, at which issues are resolved that are capable of being resolved, and only those cases that really need it have a hearing listed for final hearing. If we're able to keep within that relatively strict but simple time frame for the allocation and the going through, in effect, of the process, there is no reason why the vast majority of cases can't and shouldn't be dealt with within that 26-week period. So it's against that backdrop of the simplicity of the PLO, if I could put it that way, that we are now approaching it as a as going back to basics, really. It's right that there was an intervention of the pandemic, which perhaps might have brought things to a not necessarily a halt, but it perhaps took things off track a little. And I'll hand over to Jackie to pick up the thread from there.
Thank you, Sarah. Yes, well, as Sarah's just said, we had the mechanisms in place from 2014 onwards around the public law outline. But by the time that we arrived at 2020, in March 2020, of course, the country was hit by the COVID pandemic. And we'll all remember, I'm sure, that in those early days, and perhaps those very early days when it was being said that the lockdown would only be for 6 weeks and we'd all get back to normal after that, in those early days, the priority was on keeping the court system running as a whole, and to ensure that cases that could be heard should be heard. So that was in the initial position. And inevitably, the courts had to accept that the strict time limits and the rules around the public law outline simply couldn't be adhered to in the way that they had wanted us to previously. And it was an extremely pressured time. So that's coupled with an ever increasing number of public law cases being issued, because workflow did increase during the pandemic, required some refocusing, and the President recognised that. And he published the road ahead guidance, on the first set of guidance, on the 9th of June 2020. And within the road ahead, Mr. Justice Macfarlane recognised that certainly by June 2020 there needed to be an introduction of hybrid hearings and a move to hearings in which witnesses were going to be heard, should be heard in person, but otherwise the court should try for hybrid or should continue with remote hearings, and that was endorsed within the guidance. Specifically in relation to what we're looking at this afternoon and the timescales of the family court, the use of 26 weeks was discussed within the road ahead, and the President emphasised, even at that very difficult time, that there was going to be significant change needed in order to try to work to those timescales. He emphasised that delay was still contrary to welfare, which of course we're all familiar with. And he still said that despite the constraints around the pandemic, 26 weeks was still the court's expectation in terms of concluding proceedings. And he expressly advised and cautioned courts against adjourning matters off into the long grass, by which I mean simply adjourning for a very significant period of time. Within the June 2020 road ahead, a COVID case management checklist was provided to try to ensure fairness to parties when remote. So it was recognised that the courts were not going to be able to afford the same amount of time to hearings as they have done previously, and we've set that out for you at paragraph 43 on your slide, that there would need to be a very radical reduction in the amount of time that the court gave to each hearing, and that the issues were going to be limited only to those which it was necessary to determine in order to dispose of the case, and for oral evidence and oral submissions to be cut down to only to that which is necessary for the court to hear. So it was a refocusing, because otherwise it was foreseen that the backlogs and delays would simply mount and we would return to a situation far worse than we had before the pandemic. If we move forward then in time, some 2 years later, by the 29th of November 2022, so the end of last year, the President has reminded us again in his view from the President's chambers of the importance of the implementation of the 26-week time limit. And this was the beginning of his refocus, having emerged from the pandemic, having had courts now avail themselves of the technology so that hybrid hearings still continue where they can in some areas, but there is far more focus on getting us back in person in court, and a refocus really on a return to the previous style of working. And you can see there that we've set out the timescales that were present at the end of last year. So pre-2014, the average length of time in a case was 61 weeks. That, of course, led to the review of the system as a whole and the suggestion of 26 weeks in 2014. And you can see there, perhaps by the virtue of the fact that it was at 61 weeks, quite what a mammoth task was being undertaken. That had reduced by 2016. The national average had come down to 27 weeks. So certainly far, far closer, almost spot on for the 26 weeks. And 62% of the concluded cases were in fact finishing within that timescale. So by 2016, matters appeared to be on track. But then, of course, given the intervening years and the unprecedented workload and the combination of the pandemic, by 2022, it was said that there was no current expectation that the court could or would be able to meet that statutory deadline. So it had, to all intents and purposes, gone out of the window. And inevitably, that has led the President to want to reconnect with the PLO and to go back to what were very good statistics back in 2016. And McFarlane J said within his view in November 2022 that it is now clear to me there is a need for radical resetting of the culture within the family court so that the system reconnects with the PLO and once again aims to meet the statutory requirement of 26 weeks. So we see there, as at November last year, a real drive from the President to move things along, to get back to basics, as Sarah's already said, and to refocus the court's efforts to work to issues which are necessary and only those which are necessary, and to try to return to a far less delay for children. That was then framed into the relaunch of the public law outline, which we had on the 16th of January of this year. And this is really the starting point of the touchstones for your work and our work going forwards, if we're to comply with the wishes of the President. So we see that it was said that the normalisation of delay was reoccurring. So in effect, it was a return perhaps, or it was being seen as a return to the bad old days, where cases drifted along and there were no real timescales in place. And there was a concern that the impact on the children at the heart of each case was becoming lost. And we're all familiar with the principle against delay and the research which tells us how detrimental that can be to children in our cases. And there was a real concern that to see the timescales in cases continue to build and build back to a pre-2014 level was going to have a real impact on the children. There is a very useful and powerful PowerPoint presentation which was prepared alongside the relaunch of the PLO. It's by the Family Justice Young People's Board, and we'll send that out to you. It's only a very short PowerPoint, but it's in the words of the children at the time. And the Young People's Board spoke to children that had been through the system and looks at, for example, what if we take a period of 2 years in an adult's life, if proceedings have gone on for that long, what that actually means for a 4 or 5-year-old, and how long that can be. We all know that when they're simply waiting for Christmas, it's an extended period of time. A children's perception of time is very different to an adult's, and it's not good enough to have things simply drift along with delay after delay, and children who may be aware of their proceedings, but it must feel like it's going on forever for them. And the PowerPoint presentation from the Family Justice Young People's Board makes that point very clearly. So that's something that we were all asked to bear in mind. And coming out of the relaunch of the public law outline, the President formed the Public Law Working Group, which has had quite a mammoth task, really. There's now been a number of reports. It's led by Mr. Justice Kean, and he's chaired each of the subgroups. And each subgroup has now produced a report, and we'll have a look at the key reports during the rest of this seminar this afternoon. So the Public Law Working Group was commissioned to have a look at the issues and to make sure and to provide recommendations for how the system could get back on track, in effect, particularly post-pandemic. They led to the report initially in March 2021 and recommendations to achieve best practice, which Sarah's going to look at in a little bit more detail in a moment. But just by way of overview, it was said to be established, if you have a look at the terms of reference for the Public Law Working Group, it was established to have a look at diverting applications away from court, amongst other things. So this brings us to the pre-proceeding stage, which Sarah's already referred you to in terms of the public law outline, and the importance that only those cases which really have to be in court, going to court. It's said within the March 2021 report, and it's a quote from Isabel Trowler, the Chief Social Worker, that borderline cases, those cases which she calls and characterises as thin red line decisions, should be diverted away from the courts. And there should be clear blue water between children who are brought into the care system and those which are not. And that came out of a report that she carried out with the University of Sheffield. It's available online, called The Care Proceedings in England, the Case for Clear Blue Water, in which she sets out the way in which she sees things should progress. So the working group were asked to address compliance with pre-proceedings with that in mind, and case management issues, amongst other terms of reference. We then, as I say, have the report, March 2021, and it is a significant document. The Public Law Working Group made 47 recommendations in all. Clearly, we're not going to be able to focus on all of them this afternoon, so we're focusing at this stage on pre-proceedings and case management. And it may well be that for certainly the lawyers in attendance, it's the case management guidance, which is probably going to be at the forefront of your mind, or maybe in the forefront of your judge's mind when you appear in front of them, and therefore something that you should be aware of. I'll say just a little bit about the pre-proceedings, and then Sarah's going to look at case management with you in a moment. In terms of pre-proceedings work, it is an important stage of the public law outline, and we were familiar with that back in 2014. And as I say, there's a concern that along the way and over the years, and particularly the difficult years we've had since then, the emphasis on pre-proceedings has somewhat been lost. So the attention of all professionals is drawn to the best practice guidance, which is called Support for and Work with Families, and that's set out on your screen, to look at positive engagement in pre-proceeding support and the assessment phase, in the hope that cases that don't need to go to court can be diverted. The document that we've referred you to there, that best practice guidance for pre-proceedings, is perfectly readable. It's a 31-page document. It's something to refer to if you're involved at the very early stages of a case and want to see whether or not maybe the clients that you represent, be that local authority or parents or the children, have been treated properly and in accordance with pre-proceeding steps before the application has been issued, to see whether or not there's been any stages that have been missed, and to see whether or not really things could have been taken down a different path. The focus very much in the pre-proceeding stage of the reports is on avoiding state intervention and not adding, although it's not put in these terms, but not adding to the court delays and the court backlog. So at this stage, I will leave pre-proceedings there, and hopefully the reference that you're given is helpful if you need to look back at that. And I'll hand back over to Sarah, who's going to look at best practice guidance around case management.
Thanks, Jackie. Yes, so leading on from those initial recommendations of the Public Law Working Group, and as Jackie has already said, probably the focus of our concerns, and hopefully yours too, are those case management steps that we can and should be taking to assist the court in ensuring that it's able to make decisions efficiently and effectively in as short a time frame as possible, but of course balancing that against the need for a fair hearing and the welfare issues of all of the children involved being at the forefront of that decision-making process. What I can say is that you will have the link to the full report from March 2021, and that within that there are the appendices where you can find templates for the documents that I'm about to refer to. The use of them, to my mind, will help to ensure that every hearing counts, as the President has asked us to ensure that it does. That best practice guidance is set out at Appendix F of the final report, and as I say here, it's the go-to starting point really to allow for focused and effective management of each hearing and the proceedings generally. I would recommend the use of the agenda and the agreed minute of template in the form of Appendix F5, which is in respect of advocates meetings, which we all know can and sometimes do become not really a useful tool, but a matter of simply ticking a box. If we can get back to having effective advocates meetings, which results in essence, the directions that we're going to be asking the court to make at the hearing at which the advocates meeting is for, then that surely will mean that there is a much more effective and focused hearing that results. So there is a template for that agreed minute, and in my experience can lead to an assistance being given to the local authority advocate who's tasked with drafting the case summary, because often those minutes can form the basis of that case summary. There is at Appendix H1 to 3 various other templates for a case summary and position statements in respect of each of the parties. It is in a very different form to that lots of us have experienced, and it is right that there is often, dependent on the local court centre or the local DFJ, differing styles and differing requests. But my recommendation this afternoon is that when I've used case summaries in the format suggested by the Public Law Working Group and recommended by them with judges, they have found them to be particularly useful. And as I say here, that it does help to make sure that every hearing counts, because all of the issues that the court is going to be asked to determine, or that the court needs to know about when timetabling the matter through to the next hearing and or the final hearing, are covered. So the relaunch of the PLO on the 16th of January came with some strict missives, if I can put it that way, from Mr. Justice Kean, who is the head or leads on the Public Law Working Group, and it was he that presented the relaunch of the PLO once the President had announced that it was coming into existence. And so what I'm just going to do now is quickly run through what must happen, getting back to basics. And what is clear is that it's expected that the timelines in the Public Law Outline should be adhered to. There needs to be sufficient time between the issue of the proceedings and the case management hearing to allow for effective advocates meetings, preparation of responses, parental responses to the local authority's application, any Part 25 applications, so that the case management hearing should take place not before the 12th day after the case is issued and allocated, but importantly it should be no later than the 18th day. My suggestion is that if courts are, through lack of court availability, judge availability, pressures of time, routinely beginning to list cases after that 18-day period, that it's incumbent on all parties to be raising that issue with the court, so as to ensure that there isn't the drift that had sadly become prevalent, certainly towards the end of the pandemic and coming out of it. What's clear also is that there shouldn't be any urgent application unless it is genuinely urgent. So talking about ICO removal hearings, emergency protection order hearings, and if those are genuinely necessary, then it needs to be spelt out to the court why it's that urgent, and there must be very cogent reasons for it. It's the court to determine whether it should be listed urgently, not the parties. The parties can and should make representations as to what they say or why they say a matter is urgent, but ultimately it is for the court to do that, and the court should then list it. There is, as I've said here, an expectation that that hearing will be effective the first time it's listed, to get away from the idea of listing it for a hearing and then putting it off for another few days because people aren't ready to proceed. There has to be a clear expectation that it will be dealt with at that hearing. And as I said here, that urgent hearing mustn't delay the case management hearing. So if it is before the 12th day, then so be it, but it mustn't be capable of delaying that case management hearing any further. And whilst, again, understanding that the pressures of work for all involved, it's vital that the gatekeeping order that sets out the timelines for dates for advocates meetings, position statements, etc., but most importantly, the parent's response to threshold should be filed and served, so that at the case management hearing, all parties and the court fully understand the case that is being put forward on behalf of the parents. Part of the pre-proceedings is that there is an expectation that assessment, any assessments undertaken prior to the proceedings, will stand within these care proceedings now issued. If there is to be, or any suggestion that there be a further or updating assessment of the parents, as I've said here, it must set out firstly why further assessments are required, secondly what is the focus of the assessment, what's the timeline for that assessment, how long is it going to take, and what is expected of the parents within that assessment process. Part 25 applications must be filed and served in advance of the case management hearing. It's not okay to turn up at the case management hearing and say, we need further time to decide upon any experts whether any such application is going to be necessary. It needs to be done within that period of time, the ample period of time between the issue of the proceedings and that case management hearing. And we're told very clearly that the court must be applying the necessity test for an expert stringently, i.e. not just putting them through on the nod. At that case management hearing, it's going to be the expectation and the norm that the case is case managed through to an issues resolution hearing, and to list that hearing. It's only in the most complex of cases, so the vast majority of cases that come before the family court, before the magistrates, before the district bench, before the circuit bench, are going to be the majority of cases, and there should, if everything has been done correctly, be no need for there to be any further hearing after the case management hearing, and so until the IRH. And so that's why it's necessary to list it through to the IRH. To free up court availability and to ensure that minds are focused on the issues, it's only in exceptional circumstances that a final hearing should be listed at the case management hearing. The expectation is that the case will be resolved at the IRH, but it's only going to be in exceptional circumstances that a final hearing may be obviously needed at the case management hearing. It is acknowledged that those split hearings, including fact-finding hearings, do cause unacceptable delay and may be a reason why a case needs to come outside the 26-week timetable. But those types of hearings should be reserved, as I've said here, for truly single issue cases, or where welfare planning cannot be concluded without a determination of the core disputed facts. I think I've stressed already that it's the listing of further case management hearings. We all become involved in cases where there have been 10, 12, 15 further case management hearings. List it for review, list it for let's just come back next week to see what or how the land lies. That needs and should have ceased by now, and that there should be an expectation on all parties, and certainly from the court's perspective, that further case management hearings are only to be listed in exceptional circumstances. Moving on to the next missive that we've been given as far as getting back to basics and the PLO is concerned, that there, from my experience, I think that this is something that has largely come into effect since January of this year, that if there is non-compliance with orders, the onus is on all parties to the proceedings to be on top of that, and the court must be notified of any non-compliance, and the court will then either list an urgent hearing to rectify the non-compliance and to ensure that the case is kept on track, or it will give further directions to enable matters to get back on track. And again, this is something that I've certainly had recent experience of judges ensuring that is in place, and that parents are being given a very clear message, both by the courts and by those who represent them, that they have to now identify any potential alternative carers at the outset of the proceedings, and that if they don't do that and the names are produced right at the end of proceedings or in the midst of other assessments, that it would be unlikely that the court will grant permission for that, because the delay to the children involved in the proceedings having their cases determined is far more detrimental. And so that is something, I think, and I hope that you'll all agree, something that the courts and practitioners are being very mindful of. The IRH then, when that comes round, there should only have been, by this stage, a maximum of 2 hearings, any urgent hearing and then the case management hearing. At the time of the IRH, there should be, and I think there is beginning to become an expectation, that the issues resolution hearing is what it was intended to be back in the early days of the PLO, and a hearing that does seek to narrow the issues and at which decisions can be made. I've said here, if there is robust case management at the IRH, that can then avoid stress and delay for the children and parents. Rarely should the court simply accept that the case is said to be contested. Waiting for a contested final hearing is not welfare neutral for the child. The parties should expect the court to give firm judicial indications at that IRH with the usual caveats. If there are narrow disputed issues, for example, about the frequency of contact that a child may be having with a particular person, those should usually be fairly and proportionately dealt with on submissions at the IRH and determined, as it says. Equally, if threshold is capable of being resolved, that too can and should be determined at that IRH. If, though, it is obvious that a final hearing is going to be required, then at the IRH, the contested issues must be clearly identified. The witnesses required to determine the issues must be identified, and a fully completed witness template must be agreed prior to the conclusion of the IRH. So there's no going away from court not knowing what your witness template is looking like. The time estimate for the final hearing must be proportionate to the issues in dispute and include time for judgment preparation. And that's where your judge can assist in making sure that the time allowed and the time estimate is going to be a proportionate and reasonable one. I think everybody is aware that just because you've had an expert witness provide a report in a case doesn't necessarily mean that they would automatically be able to come to give evidence in respect of it. I think we all have experience of judges now challenging why it is necessary for any particular expert to come to court to give evidence, and that again is something that is being actively overseen by the judiciary. Ultimately, I think, as I said at the outset, the principal aims, this relaunch of the PLO, going back to basics, that there are no more than 2 or 3 hearings per set of care proceedings, and that when it can be done justly, to conclude them within that 26-week period. As I think I said, it is right that we have to accept that many DFJs and court centres have developed their own courses of action, but all I can recommend to you is, as I've said earlier, that if in doubt, and to ensure that you are behaving in a way that is expected by this relaunch of the PLO, going back to the Public Law Working Group's recommendations and the templates that they have provided means that you can't really go very far wrong. I'm just going to move now to looking at, I've said, look, everything must be done to keep it within 26 weeks. We've got to be robust about matters, but there are, of course, those cases and those sets of proceedings when there needs to be a judicial extension of that 26-week time limit. The first question that all practitioners and the court needs to ask itself is an extension really necessary? When we're looking at what is amounts to really necessary, the question must always be brought back to the welfare interests of the child, and that delay, as we've already seen and Jackie has said, in determining the outcome for children is fundamentally detrimental to their welfare. I'm going to just give you a bit of an overview. You've seen on the slides that we've given you a link to a case called Derbyshire County Council and AA and others, which was a decision of Mrs. Justice Leven, just between the President's view from his chambers at the end of November and the actual relaunch of the PLO in January. She decided in December of last year, and it's an important decision, and it's a good example of why the relaunch of the PLO was necessary, and it has brought back into focus the real question of whether an extension of 26 to the 26 weeks was necessary and whether it was proportionate to move forward with a set of proceedings. Excuse me one moment. I've got a tickle in my throat. In that case, the court was concerned with one child, a little boy, who was, by the time of the decision, aged 18 months. The first respondent was the biological mother of the little boy, and the second respondent was the mother and wife of the first respondent. So it's a same-sex couple. Not that that actually has any bearing on the outcome. But in addition to the local authority and the children's guardian, the NHS Trust was also joined as a party. The local authority and the guardian had both argued that it was necessary for the court to hold a 9-day fact-finding hearing almost 18 months after the care proceedings were issued, so way beyond that 26 weeks. Just the brief facts of that case were that in July 2021, the child had attended hospital for a routine operation. The parents had said that he'd been unsettled the evening before and asked that they be seen by A&E, where chest x-rays had revealed healing rib fractures to the 6th, 7th and 8th ribs on his left side. The paediatrician's view at the time was that these were likely to be non-accidental injuries. So as a result of that, on the 2nd of August, the local authority issued care proceedings and sought an interim care order. The court declined to make an order, and the child remained in the care of his parents throughout the proceedings, subject to a safety plan. The parents fervently denied injuring their baby and raised the possibility that the injuries were birth-related, and that was why the NHS Trust were joined as parties. Experts were instructed. I think about 3 or 4 separate experts were instructed, and the general opinion was that the injuries were more likely to be non-accidental, although the time window for the fractures did include the birth. All parties agreed that there were no risk factors or red flags concerning either parent, and this was truly a single issue case. Ultimately, Mrs. Justice Leven, at paragraph 18 of her judgment, held that I've decided that it is neither necessary nor proportionate to hold a finding of fact hearing. The fundamental purpose of public law proceedings is to determine what public law orders are needed for the welfare of the child and to protect the child from future risk. Understanding the facts and circumstances of an alleged non-accidental injury is often critical to the determination of future risk, but I do not find that it is necessary, and even if I made all of the findings sought, it would be unlikely to have any material impact on the ultimate orders for this child. In coming to this decision, the judge had decided that there was no evidence to support any finding of deliberately inflicted injury. The overwhelming probability was that if a finding of non-accidental injury was made, it would be a single act of significantly inappropriate handling of a very young baby, rather than any deliberate act or any course of conduct. There'd been detailed oversight of the parents for well over a year, and there was no cause to believe that the baby was at risk in their care. There was evidence that a safety plan was in fact causing harm to the child and was placing strain on the adults involved in ensuring that the conditions of it were being met. And the court found that even if the facts had been proved, the benefits of a fact-finding hearing would be extremely limited. It was not a realistic prospect that the court would remove the baby from the care of his parents, and a care order at home would not be justified on the facts. The court would only be considering whether to make a supervision order with the child living at home and some sort of a safety plan. A supervision plan would not have been legally binding, as the parents did not concede threshold, and the court had no power to make a public law order. Ultimately, as I say, she found that it would be a disproportionate use of court time to hold a 9-day fact-finding hearing, with the incumbent costs of the expert witnesses, the trust having representation and witness requirements from there, to determine whether it was appropriate to make a legally binding supervision plan rather than an agreed one. So I've given you the bit of the detail in respect of that, but to act as a bit of a warning, I think there's always a temptation when there is a seemingly a serious injury to a child, and particularly a young child, that could potentially be deemed to be non-accidental, and there's always often a rush to seek to have a fact-finding hearing listed, and all of the cost and the time that involves. I've had recent experience of just that, a case, if not on all fours with the Derbyshire case, a similar one, where the question was whether there was going to be the instruction of 4 separate consultant doctors to provide opinions, and thereafter a listing of a fact-finding hearing. On the back of the Derbyshire decision, the circuit judge was invited to decline to list the matter, or to direct that there should be expert witnesses to provide reports, and that invitation was made at that first case management hearing. The judge did robustly case manage, and at the end of submissions and skeleton arguments, he declined to find that the interim threshold was satisfied, and he made it clear that it was not, in his judgment, proportionate for the proceedings to continue any further. As a result of that judgment, the local authority then applied to withdraw the proceedings, and the family justice system in the family court does not have that case clogging the system up. That's an example of when when the workings of the PLO and that relaunch really do come into their own, in my view, and gives a clear indication of the mindset that we all need to have moving forwards. That said, we must still remember that it is vital to ensure that the parents, and in particular the child's Article 6 and Article 8 rights to a fair trial and to private and family life, are protected during the during the process. And the Derbyshire type cases are perhaps the extreme. So, but what we do have regularly are cases in which local authorities are seeking placement orders, that adoption is a plan for a child, and we all know that that means that the court has to be satisfied that there is no other option. And in those types of cases, it is likely that if there is good reason, if there is time for a parent to be able to show that they have changed, to explore whether there are any other real options for a child, that the balance may fall down in favour of there being an extension. As I've said here, back in 2014, Mrs. Justice Porfley said in the case of ReNL that we must seek to ensure that justice for the child and for the family must never be sacrificed upon the altar of speed. So we do need to temper our desire to ensure that we get proceedings finished within the 26 weeks with that note. I'm now going to pass back to Jackie, who's going to talk to you about another example of when it's appropriate to extend the 26 weeks. Thanks, Jackie.
So that brings us then to special guardianship orders, which, as Sarah's just said, is another area and in which you will often see extensions, and it's one in which it has been expressly recognised that there may well be very good reasons for an extension of the proceedings. So we're all familiar, I hope, with special guardianship orders. They were introduced back in 2002 by the Adoption and Children Act of that year. And the idea was that they should give an alternative form of permanence for children. They're more secure than a live with order for family members and for children, but they don't sever the legal ties in the same way as a placement order would. And one of the considerations at the time that they were introduced was around the fact that it was thought unhelpful and unhealthy for children to be adopted by close members of their family, with the legal ramifications that that brings. So SGOs were put into place, as I say, to give an alternative to put before the court in those instances. They formed part of the work of the Public Law Group, and they merited their own subgroup and their own report, which we've given you the link to there, published in June 2020, which made various recommendations, which we'll have a look at in a moment. The report produces its best practice guidance, and I would say that if you're involved in any cases involving a special guardianship order, this document is now and should be now your touchstone to look at, and just remind yourself of the framework that's in place and of the recommendations. The judges have had training around the best practice guidance and may well raise it with practitioners. So it's a document that's extremely helpful, and it's important one for you all to be aware of. The terms of reference for the subgroup of the Public Law Working Group when looking at these orders were very similar to that of the larger group, but they set out the issues that have been identified with special guardianship orders and some of the difficulties that had arisen since their implementation. And we see within the report that there's recommendations made for far better and more comprehensive assessments to be carried out by the local authorities. And importantly, and this is where it becomes relevant to the 26-week deadline, to allow sufficient time for the special guardian to have had an interim placement period, if that hasn't already existed within the proceedings. As I've said, Appendix E gives you the best practice guidance, and there is an aim to avoid what we've seen in the past, perhaps with rushed assessments and inadequate support, which is identified as a real reason for there to be risky placements and breakdown of those placements. In essence, the court is being told that before it can make a special guardianship order, it needs robust evidence as to the placement and a detailed support plan. The document also helpfully sets out the legal framework for the orders, who can apply, the time limits for which a child may or should have been placed with that person, and the process that's to be gone through. But it's recognised within the work of the Public Law Group that the 26-week ethos does severely limit the options sometimes before the court, and that if, for example, there has been a positive assessment, but the child has only been placed under an interim arrangement with their grandmother, with a view to an SGO perhaps some 2 or 4 weeks before the final hearing, that placement may very well not be in a position to be finalised, because there won't have been sufficient evidence before the court to say whether or not the child can settle and all their needs can be met. So that's led the President to expressly approve extensions in cases for SGOs. And we have the guidance of the Family Justice Council, which is referred to within the report, to help us with that. So that tells us that the child should, wherever possible, be placed in the interim with the special guardian. And although it's said to be wherever possible, I think it would be, just from experience, it would be a very unusual case where there hasn't been some form of interim placement with the special guardian, for the court to at least assess and for the parties to assess how that is going to go. So there should be a look at an interim placement, and then at the point at which the court places the child in the care of the prospective special guardian, the timetable going forward should be set out. So that will include how long might be required for there to be a proper testing period, and page 58 of the report sets out all of the factors that are to be considered. But in essence, it's to work together to form an agreed plan to progress that placement, and what it's going to be assessed by, and how it might be that final plans can then be put forward to the court. If you are faced with a case in which the plan is for special guardianship, or in fact it may not be the local authority's plan, but a parent's plan or wish for a family member to become special guardian, and that placement hasn't been tested in the interim, it is recognised that that may well lead to the adjournment of a final hearing, so that if the court endorses the plan, a move can take place and the special guardianship arrangements can then be tested out. It's obviously a balance. There will be those cases where special guardianship is the aspiration of the family members, but it wouldn't be, in the court's view, a safe interim placement. And in those instances, that's an issue in which you may see interim placements not being made, the children remaining outside of the family until the decision around special guardianship is taken, perhaps in principle, at the final hearing. But the push is through this best practice guidance for the judges not to finally approve a special guardianship order without having at least seen the child placed for a period of time. The timetable, if one's set at an interim stage, will be determined by the facts of the individual case, and we all know how different any of our cases can be. It might be that different people have different needs for support, and that timescales can be different depending on the risk factors within the family. I'll come back to the issues around supervision orders and special guardianship orders in a moment when we have a look at supervision orders in their own right. But it's right to just mention that the Public Law Working Group's report into SGOs is very clear that the making of SGOs with accompanying supervision orders is to be discouraged. And the idea is that the special guardianship support plan itself should be strong enough not to need an accompanying supervision order, and there's a lot of debate about what a supervision order would add in those circumstances. If there's a need for support, then that can be dealt with through the special guardianship support plan, or indeed through an accompanying child in need plan, if that's thought to be a better vehicle. And it's said that there should only be a very small number of cases which require more support for a special guardianship order by way of a supervision order. We know from the statistics set out within the report that during 2013 to 14, 35% of special guardianship orders had a supervision order attached to them. That was a significant increase. It was up from 18% in 2011. So there seems to have been a growing need, or a growing perceived need, to rely on a supervision order to run alongside an SGO, when that wasn't the original intention when SGOs were produced. And the research has shown that, in fact, supervision orders running alongside SGOs don't add anything in terms of outcome, be it by way of support or to prevent breakdown. This can all be found, and it was considered before we reached the point of 2020 by the Court of Appeal in a case called RePS. That's referred to within the Public Law Working Group's report. It's a 2018 case, and that highlighted, the Court of Appeal highlighted the issues that they were seeing arise with special guardianship orders. The lack of proper and thorough assessment was particularly discussed, and that's referred to within the guidance, as I say. If we come on then to the Public Law Working Group's work around supervision orders, because the two tie together. So this is another subgroup of the Public Law Working Group, and it's the most recent report. It's a report produced on the 23rd of April of this year. So the work of the group has continued, and final reports and recommendations around supervision orders are now published within that report. And there's 5 core recommendations made by the working group in respect of supervision orders. They're made both in the short term and then also recommendations for long-term change in practices around supervision orders. The working group carried out a consultation, and the report gives you the outcomes of that consultation. And as a result, it's produced best practice guidance, which is set out in Appendix C, as you can see on your screens. And again, I'd ask anyone involved in a case where either the local authority plan or the parents' plan will be to ask the court to make a supervision order, to ensure that they've looked at this report from the Public Law Working Group. It really does set out the framework now that the judges are being asked to work to, and you shouldn't be surprised if your judge then refers to it. The statistics for placement breakdown and a return to court are set out within the report, and it's been found that children on standalone supervision orders, when placed at home, have the highest likelihood out of children that are subject to any public law orders of returning to court. So it might be said, and this is my phrase, not theirs, that supervision orders pose perhaps the riskiest form of order to end proceedings on. And therefore we have to be mindful of the effectiveness of them and what they add, and that ties in with the concerns around adding them to a special guardianship order. We're all working, of course, within the least interventionist principle and principles around no orders being made if that can be achieved. The family court should always be looking to reduce the state intervention in a family's life. So to make an order that perhaps carries little prospects of actually succeeding in providing support, really there needs to be scrutiny as to why it is that's being recommended and what it can bring to the case and what it might assist the family with. So as I've said, there's core principles within the best practice guidance. They include partnership for the local authority with children and families. Multi-agency working is emphasised. The need for a clear and tailored plan and risk assessments to be carried out. And for there to be clarity around resources. So in other words, not for a supervision order plan to set out what the local authority might like to see happen if they had the resources to do it, but to be absolutely clear as to how things can be resourced and what's realistic. A lot of the plans do need a reality check at some point. There needs to then be a formal and robust review of that supervision order, set out within the plan, the point at which that will happen, how it will be run as a review, what's going to be taken into account, and how it is that the local authorities' duties around supervision and assisting the family will be held to account. So those are the core principles that the court is told it needs to refer to when looking at the contents of any supervision order plan. We're reminded within the guidance that a supervision order may only be made where the public law threshold is passed for children. And therefore the threshold itself has to be satisfied first. And the court is told to consider if support is actually needed and what benefits the order might bring. And there's always other ways we know of providing support, be that through child protection plans or a child in need plan. And with an eye to that least interventionist principle, the court and the parties need to be asking themselves, what is it about this case that makes a supervision order particularly required or apt? I've mentioned a supervision order plan. The guidance repeatedly refers to it. There is a need for scrutiny of those plans. There's a template for the supervision order plan at Annex A of the report, and when you receive the slides you'll be able to link to that, and that includes the headlines that need to be set out and need to be considered in the same way as we're used to seeing with care plans. And it's important to say that the guidance recognises that these are orders that may be sought on behalf of family members when they're not in fact the local authority plan. But it's said that before the point of final hearing, if it is that family members are going to be asking for a supervision order, the local authority should be asked to draw up that plan to show what it is they could assist with, but also to highlight from the local authority's point of view, if they really say that the order will add nothing, to produce perhaps alternative plans such as the child in need plan, and to say why it is that that might be a more appropriate mechanism. But these plans we shouldn't reach the stage of final hearings and halfway through the hearing when it's clear that a parent is seeking a supervision order instead perhaps of care order, to then have to adjourn for the local authority to formulate a plan because it hasn't been their primary position. There has to be built into the local authority's care planning sufficient resilience to be able to put forward the alternative plans, even where they don't agree and they might be saying, we say this isn't going to be sufficient for the following reasons, and these are the areas in which the support needs wouldn't be met. but it simply can't be left as it's an absence of a plan, because the court then can't consider the holistic position when, as it's required to do so by the case law, when looking at the alternative options for the child. The one final note before I hand back to Sarah on the supervision order report is that at page 75 of the report, you'll see that the issues that have been identified as requiring support for the family, so those areas that the court is satisfied are going to be helped by a supervision order, should be set out on the face of the order. That can be done in bullet point form, simply as the headlines, to say that the court has considered that in this case a supervision order is necessary and that the plan has highlighted the following areas in which the family will benefit from the local authorities' assistance and support, and then the headlines are given. So not simply left as a blank supervision order made with no reference back. It's important to set out why that order has been made and what the support areas are needed, so that when we come to review, it can be seen whether or not they've, A, the support's actually been given, but B, what the outcome has been, that it's achieved. All right, so I will hand back to Sarah, who's just going to deal briefly with a recent development that may impact upon our practices. Thank you.
Thank you, Jackie. And I'm looking at the time, and I know you've all been very patiently listening to us for the last over an hour now, so I will be very brief. I'm just referring to and highlighting the fact that last week, the 17th of May, Mr. Justice Peel, who is the judge responsible for the updating of the standard template orders that I know we are all familiar with, issued an advisory notice with updated standard orders. I'm not going to go through them in detail. The link that you will get tomorrow will take you to the page where his advisory notice appears, together with the zip folders containing the standard orders. I think the reason that we just wanted to highlight it to you is to give you another tool in your armoury to assist in ensuring that we're able to comply with the demands of the PLO. So yes, I just want to highlight that to you, ask you to go to it when you get the links through, and take particular note. Alongside the two zip folders, there is a document entitled House Rules, and it spells out in very clear and compelling terms how orders should be drafted, what should be contained within them, and most importantly, what shouldn't. What I have noted in particular is that there is a real drive to stop us from having lengthy recitals in the body of an order, and in particular when drafting those recitals, they should be in a separate schedule at the back of the order. They shouldn't be recording what happened in the hearing, and should be limited to essential background matters not part of the body of the order. Any purported views of the court which did not form part of the court's decision should not be recited. The recording of a party's position before, during or after the hearing as a recital should cease unless the particular standard order template requires such information. So yes, I just wanted to highlight that to you all, and to say simply ignore these house rules at your peril. So I think it's 5:15 now. We just wanted to finally, I think as we've said throughout, acknowledge that everybody that's attended this webinar this afternoon, and generally all practitioners, whether they be lawyers, social workers, guardians, working within the family justice system, and in particular in respect of child protection cases, are committed to ensuring the best and most timely outcomes for the families that are involved, and that we're all working at the outer limits of our capacity, and we have been doing for a long time due to the financial and other resource pressures that are placed upon the whole system. However, just wanted to finalise by saying that if we all use the rules of the PLO and the guidance of the Public Law Working Group as a starting point, we shouldn't hopefully be going far wrong. So thank you again for attending this afternoon. If you have any particular questions of us, then please do feel free to email us at events@spirebarristers.co.uk, and we will endeavour to of course answer them. And as we've already said, you will be emailed at some point tomorrow, I think with a general feedback questionnaire, but also with the slides and the hyperlinks that we've been referring to this afternoon. So thank you and goodbye.